Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a really interesting book in an area of law which is quite often something that the client forgets about, certainly the litigant in person does, and that's the enforcement of a judgment. Normally the difficulties arise over money judgments. Now we've got a book which has been around for some time called Enforcement of a Judgment. It's been published by Sweet and Maxwell, who are part of the Thomson Reuters group. And it's now in a 12th edition. It's been written by Stephen Allenson. And we're going to have a look at that book in a minute, and then I'll just tell you what we think of it in terms of our appreciation. We've written a review which has gone to the journals and the web. And the title of our written review is The Problems on Enforcement Are Paying Up, the definitive text, now in a 12th edition. And really the difficulty is, it is the problems of trying to find out whether people will pay up and how to actually deal with that aspect of it, more than other areas, but of course it does cover other areas as well. This is the book here, it just shows the hardback, and that's the spine, and then you can see at the back some information there. It's quite a heavy book, and it runs to approximately just under 600 pages. There's the index right at the back. You can see quite a detailed index, very much the standard house style for Sweet and Maxwell, so you know what you're looking at and what you're getting very quickly. There's the front page. The author, Stephen Allenson, is a solicitor and a licensed insolvency practitioner. The book was first published in 1948, so it's been around a long time. This is the 12th edition, and there's a very nice dedication, which I'll show you there. Now this is the contents, abbreviations, of which there are quite a few, CPR and so forth. Then a detailed contents section all the way through. You can see the numbers of the chapters running all the way. Third-party problems, enforcement of foreign judgments, CPR charging orders, traffic enforcement, taking control of goods, a lot of information there. Attachment of earnings, of course, which is standard again. Then the insolvency, the impact of enforcement. I think that's an important one because that's one way they sometimes have evaded trying to pay. Debt management in post-judgment, and then various other areas covered there. And then right at the end there's an index, and then there's a short preface which is worth reading, and after that the table of cases, which are fairly substantial. Then you've got statutes and statutory instruments. There are the statutes, then there are the statutory instruments. Then we get to quite a lot of statutory instruments. You've now got European legislation. That's coming into force in a lot of books today. You've got a separate section now for European and international. Then we go straight through to the enforcement debate, which is of course an important one. When the 11th edition of this book was published in 2011, the subject of enforcing judgments had been gathering some momentum following the royal assent of the Tribunals, Courts and Enforcement Act, which came into force on the 19th of July 2007. And of course there have been quite a few changes since then. But the issue remains the same, and that is how you're going to get a judgment, what are you going to do with it once you've got it? Because a lot of people who are the subject of some form of court order will act on it, but there are quite a few who don't. This is where the book comes in, because it's been a big problem for a long time, and there are quite a few people who don't take any notice, and then you've got the whole problem of going back to court to force them to do things. This is what we say about Stephen Allenson's new edition anyway. When someone owes you or your client money, a judgment in your favour by the court is only the beginning rather than the end of the matter. The next and most complex, frustrating, bewildering and difficult step is the enforcement of the court's judgment. Point I've just been making. Quote, enforcement is the most important part of the litigation process, says Stephen Allenson, the author of this enlightening, useful and undoubtedly long established work of reference, published now in a new 12th edition by Sweet and Maxwell. Without the process and the successful completion of enforcement, stresses the author, the court's judgment or order is effectively worthless. A lot of clients and litigants in person tell me that, especially if the judgment debtor, that's the chap who owes the money, decides not to cooperate and pay what is due, or worse still, never had any assets against which to enforce the judgment or order. Now, if all this sounds more than a little depressing, this book should serve to lighten the consequent gloom more than just a little, because it covers quite a precise area in detail of the various methods of enforcing judgments and orders of the civil courts, as well as the magistrates' courts and other bodies which also create enforceable awards. For example, the Technology and Construction Court, the Court of Appeal and the Supreme Court. Of course, the costs there are very, very high. The author, by the way, is, in addition to being a solicitor and licensed insolvency practitioner, he's a director and trustee of the Money Charity, and in that capacity offers a number of startling statistics which, as he says, point up the political importance of the subject of enforcing a judgment. To summarise, these include, as of September 2015, 2,330 county court judgments issued daily, 323 possession orders issued daily, and 209 people a day declared bankrupt or insolvent. Quite large figures, in fact. These figures alone indicate the need for a workable enforcement system, featuring, in the author's words, workable remedies for the benefit of those who use it. And frankly, it's a problem the law is going to have to deal with new technology. You've got to look at the practical aspects of what you're doing, and that is a fundamental point for anybody advising a client in conference prior to going to court. I do think that's something that the follow-through, which is very important. Additional provisions that we actually have include what I referred to earlier, which is the Tribunals, Courts and Enforcement Act 2007, which is relatively new. And that particular piece of legislation is considered in quite substantial detail. And additional provisions of the Act, which came into force in 2014, together with their implications, are also discussed. I think that's quite important because the coalition government did attempt to look at this, but I'm sure it'll be revisited again. But you don't necessarily need to be a practitioner to benefit from the mine of information and expert commentary contained in this book. Certainly the clarity of its plain English approach and careful organisation should make it accessible to most readers. And as I've indicated, litigants in person, whose numbers continue to increase, would be wise to purchase it. Of course, the point is that the court leaflets, although commendable, can after all only scratch the surface of what's a complicated subject. They do help a bit, but it's really, you do actually need to have a fairly substantial knowledge of how to enforce. So practitioners and legal researchers seeking further information, we think, will especially appreciate this book as a valuable research resource, offering extensive tables of cases, statutes, statutory instruments and European legislation. And for ease of use in looking things up, there's a 21-page table of contents at the back, plus a detailed index, at the front rather, the contents, and then at the back is the index. The numerous appendices include an array of useful documents which you may need, including forms and flowcharts. I'll show you those in a moment. Suffice to say, this authoritative and accessible text is a real time saver in our view. And the law is cited as accurate as of November 2015. And let me just show you the book again. There it is. There's the front, the spine and the back. As I've said, right at the back you've got a detailed index. There's the index. Then you've got these appendices. For instance, very large number of forms are included. This is how to actually deal with it. This appendix can be read in two distinct parts. So part one is the court forms, and then you go on from there to various information in part two, which is the enforcement flow charts. You can see how that works. Again, it's important probably when it comes to fairly substantial sums of money. Just opening the book up in the middle, you haven't got any any footnotes in this particular publication. What you do have is paragraph numbering, which is very useful. And, for instance, orders to obtain information, that's when you're really having a fight. And what you've done is you get introductory comments, that's dealing with CPR part 71. You get introductory comments and then the approach to how to get the information you're looking for. Then it gives the old position and the new position as well, which I think is also helpful because, as I said, this is a particularly difficult area. It's one area that's often, as I say, ignored, but it's an area which certainly all clients should be aware of. I'd like to thank Stephen anyway and everybody else involved for what is an excellent publication, and thank you to Sweden Maxwell for continuing to publish it. As you gather, it's an old publication now, going back to 1948. So thank you to all. Bye-bye.